We live. We're live. And recording paranormal activity in San Francisco. Okay. We're reading Civil Procedure California, Part 1, Subject Matter Jurisdiction in California State Courts. Jurisdictional clarification. Under California's unified trial court system, all counties have one superior court that can exercise general subject matter jurisdiction over civil matters not within the exclusive jurisdiction of another court. Okay. The former distinctions between superior and municipal court cases, however, remain in the form of two jurisdictional classifications: limited civil cases and unlimited civil cases. Limited civil cases are actions in which the amount of controversy is $25,000 or less, and restrictions are placed on subject matter jurisdiction over equitable claims, declaratory relief actions, and requests for ancillary relief. Unlimited civil actions are civil actions in which the amount of controversy exceeds $25,000, and in the full range of pleadings, motions, discovery, and equitable and declaratory relief is available in unlimited civil cases. The rules for aggregation are similar to the federal court rules, with class action serving as major exception. California superior courts have a small claim division for those limited civil cases in which the amount in controversy is less than $10,000 or less for an action brought by an individual, $5,000 or less for actions by other litigants. So, reclassification: if an action was originally misclassified, or if it was originally correctly classified but subsequent pleadings or proceedings indicate that the classification should be altered, the superior court does not lose subject matter jurisdiction. Instead, the party or the court on its own motion may move for reclassification of the action. Notice and hearing are required in considering reclassification from an unlimited civil case to a limited civil case. The court must determine that a recovery greater than $25,000 is virtually unattainable. The standard for reclassification from a limited civil case to an unlimited civil case is whether the possibility that the verdict will exceed $25,000. Other means of reclassification. The plaintiff files an amended complaint that changes the jurisdictional classification of the case. The clerk simply reclassifies the action. If the demand of a cross-complaint filed in the limited civil case exceeds $25,000 or otherwise requests relief not authorized in a limited civil case, the entire action is reclassified as an unlimited civil case. If a cross-complaint is filed in an unlimited civil case, the entire action will retain that classification, even if the cross-complaint demands $25,000 or less. Personal jurisdiction. This is part 2. So that whole first part about the subject matter jurisdictions in California state courts, that's done. Just remember, there's limited civil cases and unlimited civil cases, and your controversy is 25 or less in the limited, or exceeds 25 in the unlimited. There's crazy rules of aggregation. Which I'm not sure, I'm guessing, it's just weird. They talk about aggregation after unlimited, but I think it really pertains to limited, because it's saying California superior courts have a small claims division for those limited civil actions, which are $10,000 or less for an action brought by an individual, $5,000 or less for actions by other litigants. So, We're going to move to personal jurisdiction. The overview here is that in order for court to exercise personal jurisdiction over defendant, the exercise of jurisdiction must be authorized by statute and constitutional. The question of whether the exercise of personal jurisdiction violates due process, whether, for example, whether the defendant has such minimum contacts with California that the exercise of personal jurisdiction over the defendant is fair and reasonable, is the same in federal court as California state courts. The constitutional aspect of personal jurisdiction is discussed in the Federal Civil Procedure Outline. Statutory authorization. California's broad long-arm statute reads, a court in this state may exercise jurisdiction on a basis not inconsistent with the Constitution of the state or of the United States. That's from Cal Code of Civ Pro 410.10. Never forget it. Due to a broad nature, the authorized by statute analysis essentially merges with the constitutional analysis. Venue in California state courts, the proper court. In California, venue refers to a county in which the action can be tried. Improper venue may be waived if no timely objection is made. Local actions. A venue in a local action is proper in the county in which the land or some part of it is located. Transitory actions. Actions against individual defendants. Oh, that gets really backed up. Crazy amount of traffic suddenly out of nowhere for no reason on a Saturday. Actions against individual defendants. For transitory actions, the general rule is that venue is proper in the county in which any individual defendant resides at the commencement of the action. If no such defendants resides in California, venue is proper in any county. In addition to this general rule for contract actions, venue is also proper in the county in which the obligation is to be performed or the contract was entered, and for personal injury or wrongful death actions, venue is also proper in the county in which the injury occurred. Again, actions against corporations, associations, and partnerships. Venue in an action against a corporation, association, and partnership. Venue in an action against a corporation is proper in the county in which the contract is made or is to be performed, in which the obligation or a liability arises, or in which the breach occurs, or in which the corporation has its principal place of business. So, like, if this is federal, I have memorized this rule. I think it's 1367 or something, according to like federal civil procedure. So I can't see why it's not as important in California to know this. Oh, I'm going to just read it one more time, but maybe without the frills. Basically, in a local action, venue is proper in the county in which the land or some part of it is located. In transitory action against an individual defendant, the venue is proper in the county in which the individual defendant resides at the commencement of the action. And then lastly, for corporations, corporate defendants, associations, or partnership, venue is proper in a county in which 1, contract is made or is to be performed, 2, in which the obligation or liability arises, or 3, in which the breach occurs, or in which the corporation has its principal place of business. That's 4. Okay. Venue in actions involving unincorporated association or partnership is proper in the county of the entity's place of business if the entity's principal place of business is on file with the Secretary of State. If not on file, the venue is proper in a county in which a member of the partner resides. Okay, so there's a 2-part test. for associations. So it is easy to get mixed up on the exam about the subtle distinctions. For example, note that somewhat subtle difference in the venue rules as to individuals for state and federal courts. In California state courts, venue is proper. California county in which any. The page is gone. Page 3 and 4 are gone. All right. So we're going to move to conflict of laws. Nice clean break there. I feel like I covered everything for venue anyway. Probably missed something else though. So what did we miss? By this missing page, what's actually gone besides venue? Because I probably were just concluding on venue. Let's just say transfer or change of venue, forum and venue selection clauses, and forum non-convenes, timing of that motion. So those are the parts of venue that we didn't finish talking about. Is a transfer and change in venue, forum and venue selection clauses, and forum non-convenes. Now, I have some short notes on this. Certainly this recording and other recordings would fill that gap. All right, so according to my notes on venue, what's important to know about transfer or change of venue is defendant for all, which probably means that it requires unanimity and change of venue on other grounds. Defendant venue for one is defense for all. So impartiality is written here, convenience of witnesses, ends of justice, not be promoted, and no qualified judge. Those are some examples of changing venue for other grounds, I suppose, rather than improper venue. I'm not seeing that anything on the left section about transitory expanded for PI. Okay. That probably all has to do with what I just read. Actually, there was some more in the transitory action section. There was the main relief rule and the mixed actions. In California, you kind of like write out all the different kinds of causes of action that you have like on like a cover sheet, I've noticed in practice. So the main relief rule and mixed actions, I can see how I now giving that some thought. There's an expanded venue for contract where the contract was formed or performed. There's an expanded probably venue for personal injury where the injury occurred. Now, let's move on to the forum and venue selection clauses. What I have written here in my notes was that it's upheld only when the clause is reasonable by statute if permissible by another statute. And I'm not saying or, I'm just saying there's just kind of two bullets here. Probably an or. Say for instance, like I'm a PA resident and I engage in a contract with like an Arizona company, and I'm currently living in California, and so I bring basically the contract was signed in California, and so we're like we want to action this contract. In the contract, we'll specify to action the contract in California. So that will be given effect if it's reasonable, upheld by statute, like in Pennsylvania, Arizona, and California, and if permissible by another statute. So, like, I think that's like all three states maybe potentially have an interest. Or you would look at whether it's reasonable according to the lens of the states, all of them. Forum nonconvenes. I have California will decline jurisdiction. Permissive under statute. The timing, and I really just didn't get to write all this down fast enough. But the timing of the motion is within the time to answer the complaint if no general appearance first. So you're going to probably leave this if it's not in your first general appearance, and you're waiting until your answer. But in any case, assuming the answer needs to be within, I think, like 30. Hold on. Okay. Hi. It's striking me, I believe, the answer needs to be within 30 days, let's say. But if you've made a first appearance ahead of 30 days, you probably waived your forum nonconvenience. So I'm just going to leave that at that. So I don't have anything else written except that probably CA Civ Pro statute 418 is where more information can be found in the actual statute about this. Now, conflict of laws on page 5 or something. Under the Erie Doctrine, a federal court sitting in diversity generally must apply the law of the statute in which it sits. Thus, California's substantive law, along with California's conflict of law rules, will sometimes apply in federal court. California conflict of laws rules are described below. For more general details on the Erie Doctrine, see the Civ Pro outline. California conflict of law rules. California resolves conflicts of law issues under the following approaches: tort actions, governmental interest approach. The court first determines whether the laws of two or more states are identical. If they are not, the court evaluates whether each state has an interest in the application of its law. If each state has such an interest, a true conflict exists, and the court then analyzes the comparative impairment to each state's interest should the law of the other state be applied. Contract actions, choice of law clauses. If the choice of law clause in a contract encompasses all causes of action, the court must determine whether the clause is enforceable by examining whether a chosen state's law has a substantial relationship to the parties or their transaction, or any other reasonable basis exists for the party's choice of law. If the clause is enforceable, the court then assesses whether the chosen state's law conflicts with a fundamental California policy. If such a conflict exists, the court must decide whether California has a materially greater interest than the chosen state in the determination of the specific issue. If the contract does not contain a choice of law clause, or if it is unenforceable, the governmental interest approach generally applies. All right, so pretrial and trial procedures, commencement of action. An action is commenced by filing a complaint with the court. Filing stops the running of the statute of limitations. Statute of limitations in California, a cause of action generally accrues and the statute of limitations begin running when the plaintiff suspects or should suspect that injury was caused by wrongdoing, the underlying injuries, and not the legal theories or recovery sought dictate the applicable statute. The statute of limitations may be told while the plaintiff is a minor or incarcerated. California also has equitable tolling, which suspends the running of the statute in the interest of fairness as long as the defendant is not prejudiced thereby. Oh, interesting. Those two people that just went riding off on that motorcycle, they they must have came back and parked their motorcycle. A ladybug just landed here on my balcony. That's lucky. Wish it would have landed on me. So, and it's very small, dark red. So, equitable tolling. This is a lot of tolling features here in California. Like, they're pretty gratuitous here, pretty gracious here. Like, filing stops the running of the statute of limitations. So what that means is like probably supersedes amendment, because you have to relate back. If you amend a complaint that was filed before the statute of limitations ran, but then before or after the statute, you want to amend after the statute of limitations is run in federal court, you have to relate back to the original complaint. And that would not be the case here because literally filing a complaint stops the running of the statute of limitations. So I don't know if maybe we're not going to talk about amendments here. That's fine. Service of process. Parties served inside California. California statutes authorize service of process by non-parties over the age of 18 on defendants within California by personal delivery, substituted service, which is leaving a copy of the summons and complaint at authorized locations with specific individuals, followed by mailing, service of mail, and service by publication. California also has notice and acknowledgement of service provision under which the defendant will become liable for the cost of service if he has not acknowledged receipt of the summons and complaint by mail. Literally, this whole paragraph is great. Thank you. There is another subtle distinction between California rules and the federal rules for your exam when substituted service at the defendant's home is made. California state courts require a follow-up mailing to the defendant, whereas there is no similar requirement in federal court. Parties served outside the state but in the United States. In California state courts, in addition to the methods authorized for service on in-state defendants, service of process on a person outside of California may be made by first-class mail, by postage prepaid, requiring return receipt, but note that a proper statutory and constitutional basis for personal jurisdiction must exist. Parties served in a foreign country. In California state court, in addition to any manner authorized for in-state service outside the United States may be made as the court directs, or 2, if the court finds that the service is reasonably calculated to give notice as directed by the law of the place where the person is served or by the foreign authority in response to a letter of request. An international agreement such as the Hague Service Convention may govern service in signatory countries. 4, no immunity from process. California state courts do not recognize immunity from service of process when the defendant is in California to participate in the litigation. Interlocutory injunctions, preliminary injunctions. A party may seek a preliminary injunction prior to trial to preserve the status quo until a hearing on trial on the merits may be held. The adverse party may be given notice and an opportunity to be heard. temporary restraining orders. If irreparable injury will occur before the hearing on the preliminary injunction can be held, a party may seek a temporary restraining order to preserve the status quo until the hearing. Generally, the adverse party must be given notice of the hearing, but a TRO may be imposed without notice if 3 conditions are met. The moving party states specific facts in an affidavit or a verified complaint of the irreparable injury she will suffer, and if the TRO is not granted, there's your irreparable injury. There's some other stuff here about an affidavit and verified complaint. It's not like those terms are defined, so I just kind of conceptually understanding that maybe a verified complaint is one that comes with like this affidavit. The moving party certifies in writing the efforts she made to notify the adverse party of the reasons why notice should not be required. And third, the moving party provides security to pay for damages incurred by the adverse party if the court later finds he is wrongfully restrained. Okay. Those are typical. Although a TRO may be issued ex parte, a person must have notice of the TRO before he can be bound by it. Security. The court has discretion to issue a TRO without a bond or undertaking. In contrast, the court must require an undertaking for the issuance of a preliminary injunction. Time limit. A TRO expires automatically when a preliminary injunction is either issued or denied. If no notice was provided to the opposing party, the court will set a hearing on the application for preliminary injunction within 15 days of the issuance of the TRO or 21 days if good cause is shown. Pleading. State courts have fact pleading or code pleading but require a heightened specificity for certain causes of action, example, fraud. California courts liberally construe pleadings. Complaint. All complaints and cross complaints must have a statement of facts constituting the cause of action, and 2, a demand for judgment. If damages are sought, the amount must be stated except in actions for recovery of punitive damages or in personal injury or wrongful death actions seeking actual or punitive damages. Instead, the defendant may request the plaintiff to serve a statement describing the nature and amount of actual or punitive damages. Challenges to the complaint. It's like, how is that different than federal court? Federal rules of civil procedure, they want a clear and plain statement. So is it rule 8 or rule 8 or something? A clear and plain statement of the cause of action. You need to justify jurisdiction in federal rules of civil procedure. You need to pray for relief as here. What else do you need? I can't go back in and look for it. What does the federal rules of civil procedure require for a complaint? Simple, concise, and direct. No technical form is required. Short and plain statement of the grounds for the court's jurisdiction. Unless the court already has jurisdiction and the claim needs no new jurisdictional support, a short and plain statement of the claim showing that the pleader is entitled to relief, and a demand for the relief sought, which may include relief in the alternative or different types of relief. That's actually it, and I was right. So, California has a different. You don't really need to argue jurisdiction. That's about it. I mean, the words are different, but those elements are the same. Damages, you don't have to give a specific amount if you're seeking punitive, wrongful death, or personal injury. No, that's the Federal Rules of Civil Procedure. Don't go into that. Challenges to the complaint. Instead of or in addition to filing an answer, and after conferring with her opponent 5 days before filing it to resolve the pleading dispute without court intervention, the defendant in an unlimited civil case may file a pleading known as a general or specific demur addressing the entire complaint or individual causes of action contained in it. No special demurs may be filed in a limited case. The grounds for a general demur are: 1, that the court lacks subject matter jurisdiction; 2, that the pleading fails to state facts sufficient to constitute a cause of action. Special demurs are those based on a lack of legal capacity to sue, existence of other pending action between the same parties in the same cause of action; 3, defect or misjoinder of parties; 4, uncertain pleadings, similar to a motion for more definitive statement in federal practice; and 5, failure to plead whether a contract is oral or written; and 6, failure to file certain required certificates. So when can these happen? In addition to filing an answer, after conferring with the opponent 5 days before filing it. 5 days. That's like nothing. Whereas like probably in federal practice, 21 or something, to let these people know that their answer is effective, and to amend it. And I think, but I don't know. All these details about your general demur and your special demur, this is all California specific. Because federal rules of procedure don't have a demur. They have all these separate other kinds of things. Like failure to join. We're saying motion for more definitive statement, motion to strike, motion for summary judgment, motion to quash, or something like that. I don't know. There's a lot. In ruling on a demur, the court considers only the material allegations pleaded in the complaint, which the court assumes to be true. The matter subject to the judicial notice. The plaintiff may file a demur addressing the affirmative defenses in the defendant's answer. The party may not file a demur to an amended pleading if the grounds for the demur could have been raised in the earlier demur. So, okay, so actually, I'm going to read the different kinds of in the Federal Rules of Civil Procedure. There's a lot of defenses. Can I go to the next section? Well, I was right. It was Rule 8 of the Federal Rules of Civil Procedure, but I can't go to the next section, so we're screwed. Keep going. Motion for judgment on the pleadings, a JOP. I think this is like a summary judgment, but in California they call it a JOP, a judgment on the pleadings, which may be made on the same two grounds as those for a general demur, and the same evidence is considered. However, unlike a general demur, JOP motion may be brought after the defendant files an answer. Motion to quash service of summons. Ooh, see, that's an actual California thing. It's not a federal thing. That's the problem with learning two at once. So, motion to quash service of summons. Defendant objecting to the court's exercise of personal jurisdiction over him must raise the objection at the earliest opportunity, most commonly by special appearance via a motion to quash service of summons. If the defendant files a motion to quash before or at the same time as filing the answer demur, motion to strike, the defendant will have preserved the jurisdictional objection. In contrast, to the federal procedure, a defendant in California state court may not object to personal jurisdiction in an affirmative defense in the answer, then proceed to litigate the action and raise the objection at or close to trial. I didn't know that could happen in federal court either. Motion to strike. Before responding to a pleading, a party may move to have stricken any insufficient defense or any redundant, immaterial, or scandalous matter. Anti-SLAPP motion to strike. California has an additional type of a motion to strike when the plaintiff has filed a strategic lawsuit against public participation called SLAPP. In the anti-SLAPP motion, the defendant must make a threshold showing that the cause of action in the complaint arises from activity protected by the First Amendment. If the defendant makes this showing, the burden shifts to the plaintiff to show how a probability of prevailing on the merits. The burden shifts to the plaintiff of showing a probability of prevailing on the merits. I wonder what it is. The cause of action in the complaint arises from activity protected by the First Amendment. I wonder what that means. I honestly don't even know what that could possibly be. We're saying a plain. So if I say you defamed me, and then they say, yeah, but defamation is a constitutional right, you're bringing a lawsuit just to harass me for exercising my First Amendment rights. The California legislature has created exemptions for actions brought solely in the public interest or on behalf of the general public, and for actions brought against sellers of goods or services who make representations about their business or competitors' business. The defendant who prevails on an anti-SLAPP motion may bring a SLAPP back motion, basically a cause of action for malicious prosecution. All right, so answer. We have 10 more pages. This is painful. This is painful, even though it's really relevant, and I wish I paid more attention to it last time I sat for this exam in July. It's painful. If I did, I would have been so much more prepared to actually work at a civil law firm. If I actually paid attention to this. Answer. Usually, a defendant may file a general denial, which denies each and every material allegation of plaintiff's complaint. The defendant also has the option of filing specific denials, which any particular paragraphs or parts of the complaint and which permit defendant to deny allegations on the basis of information and belief or lack thereof. If the plaintiff has filed a verified complaint, the defendant usually must respond with a verified answer that contains specific denials. Any material allegations not denied by a defendant's answer are deemed admitted. In pleading affirmative defense, the defendant must adhere to the same fact pleading standards as plaintiffs, or the answer may be subject to general demur. The defendant has 30 days from the date of service of process to file an answer. All this seems really familiar to what happens in federal practice. If a defendant instead brings a demur or a motion to strike and the court overrules the demur, denies the motion, the defendant must file an answer within 10 days unless the court orders otherwise. Effective failure to answer. Default and default judgments. If a party against whom a judgment for relief is sought has failed to plead or otherwise defend, and that fact is made to appear by affidavit or otherwise, the clerk must enter the default of that party. Entry of default may also be ordered as a result of defendant's misconduct, such as for failure to comply with discovery obligations. Once the default has been entered, the party may not proceed with the action until the default has been set aside by the court. In California state courts, a notice that a default may be entered must be mailed to the defaulting party. Default judgment. Once a default has been entered, the amount of damages must still be determined before the absentee or available parties to the extent to which such prejudice. Did I miss a page there? Am I missing a page? Oh, I'm missing pages. All right, so default judgment. Once a default has been entered, the amount of damages must still be determined before. All right, so I'm missing page 9, 10, 11, and 12. But I have my outline here that I wrote on the subject matter in those sections. So as to fill the gap between the default judgment section. Okay. Weird. It's not. Oh, here it is. Okay. So where did I just leave off? Talking about a default judgment. Okay. So default judgment. It's like the CMR just totally skipped over entry of default and just went straight to default judgment, whether it be entered by the clerk or the court. So I'm just going to talk about the default quickly. This is a failure to prosecute or defend, must be entered by the clerk, some certain to be entered by the clerk, action, something about service, really. And I guess maybe if it's not served properly, it can be set aside or something. But default judgment entered by the clerk. What I'm saying here, okay, the judgment. In order for judgment to be entered by the clerk, it has to be for some certain action not served by publication. That's what those words meant. Okay, sorry. I can't read my own handwriting. In 60 days and notice of application. For a default judgment to be entered by the court conducts a prove-up hearing and plaintiff must make a prima facie case, including statement of damages, statement of punitive damages. Setting aside a default or default judgment is permitted, but I don't have any of the details. Then you'll get into the missing pages, would get into the cross complaint. That's the only label used. You don't have a cross complaint and a counter complaint. You just call them all cross complaints under a single label. The compulsory cross complaint, related defendant versus plaintiffs, requires the same transaction occurrence as expected, and for a permissive cross claim, they may be brought together or in separate actions. These can be others unrelated to the transaction or occurrence. I've got here compulsory requires the same transaction or occurrence, facts, information, or belief, or incorporated by reference. See section, I think, like 472. Alternative pleadings, I don't really have much about that. Pleading facts, ordinary and concise of ultimate facts, heightened specificity for fraud. We talked about that. Amended pleadings, matter of right before the hearing one time. There was more about pleading facts. Fact pleading, code pleading, civil something. Okay, civil conspiracy. Okay, so you want to have heightened specificity for more than just fraud. Civil conspiracy, I think, tortious interference with the contract, unfair business dealing, unfair business practices, product liability, multiple defendants from exposure to toxins. Amendments. Thereafter, okay, so we're talking about the amendment. After the one time by right or demur or within 2 times reply to demur, thereafter only allow amendment by leave of the court upon a motion, and then relating back to the date of the timely filed complaint based on same general set of facts, same accident, same injury, same offending instrumentality. And for amendments, California's super special. They have this thing called like Doe amendments. Amendment to add an absent showing of additional facts. I don't know. But the Doe amendments, and then so there's three different kinds of amendments. One is to amend to add a new cause of action against a defendant already named. Two is and I think I just read that. And two is the California Doe amendments. And third is to conform to the evidence. So Doe amendments is to help discover an ID of the perpetrator. So you file a complaint stating a Doe as the defendant because you don't know who the actual wrongdoer is, and so instead you substitute Doe, and then when you determine who it is, you can amend the complaint within 3 years when you discover their identity. For under fast track may not be dismissed until after prosecution of presentation of evidence at trial is completed. So certification upon presenting paper to court. Right, this is analogous to the Rule 11 under the Federal Rules Civil Procedures, effectuating sanctions. It requires, so in California, I think it requires due diligence. It's the same as the federal exception is what I've written here. So on the court's initiative and on the parties, opposing parties' motion, 21 days to correct or withdraw a matter allowed on sua sponte notification of party, as well as the opposing party's motion. I've gotten to joinder of parties and joinder of claims. Interestingly, I am missing some of that, but I discussed some of it. So I'm going to actually close this down and read that in last time pages in the second session.